So first of all, if there are any veterans in the room, thank you for your service this weekend. And second, I love the fact that you say to yourself, it's the start of the last 3-day weekend before the weather changes. Let's lock ourselves in a room with a lawyer and talk about forms. So you guys really know how to party up here. I mean, I come from a party town, but you guys are making it look like Vegas doesn't know anything. So way to go, you guys. So today we're going to talk about the buyer brokerage agreement. We're going to talk about the listing agreement. We're going to spend a few minutes talking about my favorite thing in the world, wire fraud. And then I'll take some questions. If you have specific questions that are not form related, I'll be more than happy to stick around. My flight doesn't leave till 5, so I got plenty of time. So we're going to jump right into the buyer brokerage agreement. I know that you don't necessarily have to use a buyer brokerage agreement. I'm a big fan of using a buyer brokerage agreement. Aside from the fact that it's going to help you if you ever have a procuring cause issue, there's a couple provisions in this document that will really protect you if you ever have to go down to the courthouse and get sued by a client. So let's go ahead and walk through this. First section, you identify the buyer, the broker name, giving a exclusive irrevocable right for the time period, and then you identify the type of property you want to use. The buyer obligations under Section 2, that they agree to work exclusively with you. We had a scenario in Southern Nevada. We run about 100 to 200 professional standards cases a year. It's part of my job. I get to sit on those, which makes running into realtors in public awkward for them and not for me. And we had a scenario of a procuring cause case where they had an investor who was from another country who didn't understand the concept of exclusivity. And they said, one of the panel members asked him, "Did you sign a buyer brokerage agreement?" He said, "Yes, I signed 7 of them." So after that hearing, we decided to add this language here that you're going to agree to exclusively work with me. And it was so surreal. He literally had 2 agents making competing offers on the same property at different price points.
Negotiation at its finest.
Yeah, but they were negotiating against him. They were like going back and forth and raising the price. It was surreal. So, buyer agrees to provide the broker all the necessary documents, including loan pre-approval letters, proof of funds, etc., to allow them to, and then authorizes the broker to provide those documents to a potential seller. They agree next to be available and work with you and respond, act in good faith with inspections, etc. We have a language about new homes that some sellers, and I don't know if this is your market, but it's definitely our market in Southern Nevada, particularly new home subdivisions, open houses, and for sale by owners, will not necessarily compensate the broker unless broker makes the first visit with the buyer. If buyer makes a first visit without broker, buyer agrees to compensate broker as stated in broker's compensation below. So we put that language in there to give you the ability, if you want to, when you have that new home scenario where they don't offer a commission to you, to be able to have the business option to potentially go after the buyer if you want to. You don't necessarily have to, you could always waive this, but we put the language in the contract for your individual business models to make that decision. Buyer agrees also, we also threw this in after our friend with the 7 brokerage agreements. Buyer agrees that to the fullest extent allowable under Nevada law, the broker shall be deemed procuring costs for any and all successful real estate transactions which arise from or originate during the term of this agreement. Any questions on that so far? All right, let's jump into the broker's representations. You agree that you actually have a Nevada real estate license. You agree to work diligently and to negotiate in terms in their best interest. And then we walk to the compensation section. Let me go through all of this, and then I'm sure you'll have some questions. So we have a percentage, a flat fee amount, or whichever is greater of 1 or 2. So if you have different business models, we try to be mindful of a variety of different brokerage models, not necessarily for our friends in the Department of Justice for antitrust purposes, that you individually have the ability to do different types of business models, flat fees, percentages, combinations. For those of you who were here yesterday, I joked that if you were interested in the Dave Sanders real estate experience, it would be a 95% of the purchase price or $50,000 in certified funds. You could do that. It's totally legal. So we wanted to give you the ability to do this. And then B, is also if you have an additional fees on top of this. Some brokerages do that. You could always put NA there if you don't, but some brokerages charge a specific flat fee in addition to a compensation commission at this point. So you could certainly put that in there if you want to. I'm very limited on what I can and can't answer about this stuff due to federal antitrust laws. So, buyer agrees to compensate broker if the buyer or any other person acting on the buyer's behalf enters into agreement to purchase, exchange, option, lease, or lease of and property of general nature described here. And we added this section because we had the following scenario involving an arbitration. We had son wanted to buy a house, went to the agent, couldn't qualify, just started a business, didn't have the financials to get a loan. His father, however, decided to purchase the home, but the father did not like the original agent. So even though the original agent showed the property to them, father decided to go to a different brokerage, and so they brought a procuring cause case. And it was very, very awkward because he was one of the federal judges that sit in Nevada. So he was there, and the agent who was alleging that he had started the procuring cause the judge had no idea who he was. He was actually addressing the broker saying, "You never talked to me, you never talked to me." And the broker had to interrupt and say, "You're actually talking to my agent, I've never met you." Which, as a side note, if you're going to bring a procuring cause case, you should probably know who your client is. So we added this language to address the scenario that if you had that situation, you'd have some potential language, you could bring a procuring cause if you want to. The other takeaway from the judge case was if you have a scenario where you have somebody who may be doing the actual financing, if he'd been CCing the judge on those emails throughout, I think the hearing panel may have come to a different decision. They were not successful that day. So then you have this language here that allows if the transaction is prevented by a buyer's default, then you can request compensation under that. So if they just stop cooperating or they breach the contract, you would have the business opportunity, if you chose to potentially go after the buyer for any commission. If they terminate, they agree X number of days. You could put in how many calendar days you want to say, if you decide to breach this agreement, my total compensation would be due on X day. Again, you don't have to use this. We wanted to give you the opportunity if you wanted to. And then commissions payable for purchase, exchange, option, or lease of property are not set by the Incline Village Realtors or any board or association of realtors or multiple listing service in any manner other than is negotiated between broker and buyer, making it very, very clear that the MLS or the association doesn't have any involvement in the amount of commission. Let's go to the next page. So, disclosures, talk about duties owed. We talk about, this is the language that you were asking for, 5B. Buyer understands that depending on the circumstances, it may be necessary or appropriate for broker to act as an agent of both parties for each such transaction. In such event, broker will seek buyer's consent to broker's representation of additional parties as soon as practicable and obtain the written consent to act form signed by all parties. Buyer consents and acknowledges that other potential buyers represented by the broker may consider, make offers on, or acquire interest in the same or similar properties as buyer, basically telling your client that you have other clients and they may be looking at the same properties you are. 6, this is something that I think a lot of people are surprised about, but unless your purchase agreement, and the one we talked about yesterday does not have one, has a confidentiality agreement or a provision, the terms of the contract are not confidential. They're not. Contractually, there's not a provision in it that says that they must be. So we tell people that. Buyers advise that the seller or listing agent may disclose the existing terms and conditions of a buyer's offer unless all parties and their agent have signed a written confidentiality agreement. Whether such information is actually disclosed depends on many such factors such as current market conditions, the prevailing practice in the real estate community, the listing agent's marketing strategy, and the instructions of the seller. And we'll get to the listing agreement where we talk about that. But for example, if you had a confidentiality agreement and you were the listing agent and you disclosed, I have multiple offers, guess what you've just done? You've materially breached the confidentiality agreement. So I'm not suggesting that you should, go out and share the specific particulars, but be mindful that when you say things like, I have multiple offers, or send me your highest and best, or those types of things, you are disclosing the existence of our documents. And if you have a very narrow confidentiality agreement, and there might be scenarios where you have high-end clients or clients who want that type of confidentiality, just make sure that you're very mindful not to breach it with your standard practices in real estate. So, any questions on that? Well, what I'm saying is you can say that because there is not a confidentiality agreement. If there was a confidentiality clause in the contract saying, I have received multiple offers above list price, is a breach of that. So most people think that there's some sort of confidentiality to the purchase agreement and to that process. I just wanted to point it out that it's usually not, because if you're a seller, you may want to act in the seller's best interest to disclose that. It might be in the buyer's best interest to know that they're competing against multiple offers so that they bring their highest and best from the get-go. So just wanted to point out, because it's a common misconception that the contract is confidential. And if there's a confidentiality clause, then you can't even disclose the existence of multiple offers. So I don't know if that's in your best interest. Okay? So basically, do what you're continuing to do. There's nothing wrong with that. Just to point out that if you ever get the scenario where a client wants confidentiality, you need to be mindful of disclosing the existence of any offers. Okay. Let's talk about number 7. Internet advertising, internet blogs, and social media. Buyer acknowledges and agrees that properties presented to them may have been marketed through a virtual tour on the internet, permitting potential buyers to view properties online, or that the properties may be the subject of comments or opinions of value by others online, on blogs or other social media sites. Neither the service providers nor the broker have control over who obtain access to such services or what actions such persons may take, and broker has no control over how long the information is on the internet. So we put this here because, and I don't know about your MLS up here, but we get phone calls all the time from angry buyers saying, I purchased my house 2 years ago and it's still on the internet, I want you to take it down. Like, I'm the master of the internet and I can do that. So we put this phrase in so that you can explain to your clients, look, once it's on the internet, and there's similar language in the listing agreement as well, once it's on the internet, we have no control over where it goes. So buyer, if you buy this house and it's on the internet, we don't have the ownership rights necessarily, depending on your syndication agreements, to pull that, okay? This is designed to protect you so that when you get those angry phone calls down the road, you can talk to them and say, no, we already talked about this. We don't have the ability. And it's typically, it's usually not like the Zillows, the Realtor.coms. It's usually those virtual tours, or hey, we'll give you a free website. If you enter into those kind of agreements, you really need to look at what they can do with derivatives on that, what they can do. You're typically giving them all of the rights in your listing data, so you may want to be mindful of checking that. Any questions on that? It's on the buyer brokerage agreement, and we have similar language in the listing agreement to tell the seller that, hey, once we send this MLS data out and we syndicate it, we don't really have the ability, once it's on the internet, to pull it down. So we put it there. All right, equal housing opportunity. It is the policy of the broker to abide by all local, state, and federal laws prohibiting discrimination against any individual or group of individuals. The broker has no duty to disclose the racial, ethnic, or religious composition of any neighborhood, community, or building, nor whether persons with disabilities are housed in a home or facility, except that the agent may identify housing facilities meeting the needs of a disabled buyer. Okay. Number 9, other potential buyers. Buyer consents and acknowledges that other potential buyers represented by broker may consider, make offers, or acquire an interest in the same or similar properties as buyer is seeking. We have a mediation provision. The broker and the buyer agree to mediate any disputes they have over this agreement. And let's go on to number 11. My favorite section, the attorney's fees. It's a prevailing party provision. It's a standard provision. Damage cap. Now this makes me very happy, and this is a recent version we added, and we added this language to the listing agreement and the buyer brokerage agreement. As an attorney, if you ask me what was the big reason why you should use a buyer brokerage agreement, it's this phrase right here. A damage cap is a contractual obligation where the parties agree to limit the amount of damages the buyer can get if the buyer sues you. So when you go to trial, and those of you who haven't done it, you do two things. The first thing is you prove liability. Who's responsible? Who caused the car accident? Who breached the contract? And then after that, you do a prove up of damages. Yep, I rear-ended you. Now you have to prove your medical expenses, all that kind of fun stuff. And what this does is this language says, notwithstanding any provision to the contrary contained in this agreement, if broker shall be liable to buyer for any matter arising from this agreement, whether based upon an action or claim in contract, warranty, equity, negligence, intended conduct, or otherwise, including any action or claim arising from an act or omission, negligent or otherwise, of the liable party. Yes, I tried to think of every possible lawsuit on the planet in that sentence. The maximum aggregate liability of broker to buyer under this agreement shall not exceed the aggregate commission amount received by the broker. Meaning, we're seeing a lot more lawsuits of people suing real estate agents. And what will happen is the buyer and seller will sue each other, and then they'll throw you guys in because we know you have, lawyers like me know you have E&O insurance. And we know your insurance company's probably going to be able to throw some cash at us. What this does is this says, no matter what, the best you're ever going to get, Mr. Buyer, and your best day at trial is the amount of commission you paid me. It's designed to deter frivolous lawsuits. It's also designed to protect you. And these are routinely upheld in states, in courthouses across the country. So we put this recently in our buyer brokerage agreement and the listing agreement to protect you from the increase of lawsuits that we're seeing throughout the state. So here's the fun thing about Nevada. We don't really have a whole lot of case law. So we look at other states. I can tell you that this provision is quite common in just about almost all contracts. It's also quite common in real estate contracts on the Atlantic coast. So we were looking at what ways we could do to continue to protect you guys. And this was probably one that I thought was probably the better things we've come up with in the last little bit. Now, I'll get your question in just a second. Now, unfortunately, because you are waiving a remedy, it has to be done in writing, meaning that the only way that we can get you to get this protection is by putting it in an agreement that the buyer and the broker sign. So it's going to be in the listing agreement, so every time you have a seller client, that language will be in there. This would be the reason why I would recommend you use a buyer brokerage agreement, just for the protection that it'll cost. Now, will this change your day-to-day business tomorrow? No. If you ever get sued, will you probably want to call me and say thanks? You betcha. But so I think this is probably the biggest thing we can do to protect you. You had a question. The question was, why wasn't this added to the purchase agreement? And the answer is, the purchase agreement is a contract between the buyer and the seller. This is designed to protect the real estate agent, the brokerage. And so it has to be, to waive that right, it has to be between a contract between the brokerage and their client. So listing agreement, buyer brokerage agreement. Okay? Yes, sir. So his question was, I have multiple buyers looking at the same property. What happens if buyer A says to me, what did buyer B offer on this? So that's always going to be a little tricky situation for you because you always have to act in the best interest of both of your clients. I would probably answer that in the way of, let's put your best offer on the table and not worry about what other clients do, because that I could see could be you necessarily confidential or not, you also have under Article 1 of the Code of Ethics an obligation to act in all parties' best interest. And I don't know if it is in one of your seller's best interest for you to tell the other seller what they're offering so that the other buyer, so that the second buyer could try to up that price. That's a tough spot. I would probably focus on let's offer, what your best offer is, and we'll see what the seller decides to do. That's. So to answer your question, that's a tough spot to be in, and I would certainly be mindful, but we can talk afterwards about a couple options there. Any other questions about the damage cap? I'm not suggesting, actually, I would suggest that if you have buyers, clients, that you start using this document as quickly as possible. If I have listing agreements, we'll talk about it in the listing agreement as well, I would recommend that you get those switched over as quickly as possible just to protect you. I also am mindful of the logistics of what I'm suggesting, but this language is available now, and it's in those documents. Number 13, we are executing this document under the laws of Nevada, and that the parties agree that we will sue in the state of Nevada with the county where the property is located. Pretty standard venue provision. 14, capacity. Buyer warrants that the buyer has the legal capacity and right and authority to enter into this agreement and consummate the transaction contemplated hereby on buyer's own behalf or behalf of the parties buyer represents. This is designed for if you have a corporation, that the person who is signing on behalf of the corporation or the trust is making the representation that they have the legal ability to do that. And the last sentence, buyer's obligations to pay the broker is binding upon the buyer and buyer's heirs, administrators, successors, and assigns. Number 15 is an entire contract provision. It just basically means this is everything that we've agreed to. Pretty standard contract. And then we have language that says that the parties will agree to amend it in writing. 16, standard legal boilerplate stuff, partial invalidity. It's a provision that says that if a court decides one of the sections of the contract are invalid, it only applies to that section, the rest of the agreement stands. Pretty standard contractual language. Buyer declaration, we added this in again because of our good friend who signed 7 buyer brokerage agreement. Buyer acknowledges and warrants by signature below that he is not already in an exclusive buyer representation agreement with any other broker in the state of Nevada. Entering into multiple agreements could subject you to multiple fee obligations. Buyer acknowledges that he or she has not relied upon any statement of the broker which is not herein expressed. Any questions on that? Again, putting the idea that you're explaining to the buyer that this is an exclusive agreement and you can sign multiple. You may have to pay multiple fees if you do so. 18, buyer agrees to all the terms. 19, FIRPTA. We only do a few sentences about FIRPTA with the buyer, just explaining that, hey, if FIRPTA applies, you may have to withhold taxes as required by our good friends in the Internal Revenue Service. Default. If completion of any transaction is prevented by buyer's default or with the consent of buyer, the total compensation due under this agreement shall be immediately due and payable by buyer. Buyer agrees to pay such compensation if the buyer within blank calendar days after the termination of this agreement enters into an agreement to purchase any property shown to or negotiated on behalf of the buyer by a broker during the term of this agreement, unless buyer enters into a subsequent agreement with another broker. If completion of any transaction is prevented by buyer's breach or with the consent of buyer other than as provided in the purchase contract, the total compensation shall be due and payable. Again, expressing to the buyer that if they bail out on you, they may still have to pay you. Let's go on to the next section. 21, additional terms. And then we have the language that this form has been approved. If you have legal questions, talk about it. And then you have the signature blocks for both parties. 3 pages, so not the longest contract we've ever written, but some pretty good stuff in there.
What happens if the agent and the client just don't click? I mean, there are some agents that don't make it. Well, I don't know what else to say.
I get along with everyone. I don't know what you're talking about.
That's true what I'm saying.
Yes, so
You know what? This isn't working.
So there's a couple of things. This agreement is one, it's between the buyer and the brokerage. So what we tell the brokers is they're having a problem with one agent. If you've got more than one, you sit down, you have the conversation, and you do it that way. To address your question as to when you should execute the buyer brokerage agreement, we did have an arbitration case to the tune of about $100,000 that came down to one question. They had 2 agents claiming they were procuring costs, and one of the major factors was they both had buyer brokerage agreements, but the factor came down to when they signed them. One signed them, had them executed as soon as they met and they had that first presentation. The second one signed it right when they started showing homes, like right before they submitted an offer, and there was a significant time difference between the 2. If you're going to use a buyer brokerage agreement, and again, that's a business practice that you can decide whether you want to or not, if you're going to do it, I would recommend you do it at the very beginning of the relationship to avoid scenarios. The one who had it executed at the beginning of the relationship. Well, this is an agreement between the buyer and the brokerage for compensation and representation. Pursuant to NRS 645, only a broker can enter into these types of agreements. So we have a designated licensee language so that the agent can be identified, but the agent cannot be a contractual party to this agreement because that violates state law. So the broker has to sign it, and the designated licensee can be identified. So if you are my broker, you would sign this, and then my name would go here. Does that make sense? So they don't run afoul of, because we didn't want agents signing this and then having our good friends at the division, bring you down and have to explain why you are violating state law. We added this language after that fact. I mean, this was a very interesting arbitration for me to sit through because of the unique situations that came up. It was a very high price point commission. They were working with one group, and it was interesting. There were some language barriers there as well. For example, the client, the first agent's the one who signed the agreement right before they made the offer. They had a teenage daughter who was like a senior in high school, and they were doing the standard on a lot of weekends, going out and looking at universities to see where she wanted to go to college. And they didn't communicate that well. The buyer assumed that they were, quote, going on picnics all the time and didn't have time to sell me real estate, so we went to somebody else. So it was very interesting because the first thing was, there was a breakdown in communication and expectations with that client, and it was kind of mind-boggling to me that when you have somebody come in and says, I want to spend between $1 and $3 million on a house, that you don't. Yes, I get that you have, and I'm a single dad. I totally get the parental thing, but I didn't understand why they didn't have someone to step in and handle that while they were doing the college visits, because that prompted him to go somewhere else. And then he signed a couple of buyer brokerage agreements. Depending on if you have foreign investors, depending on which part of the world they're from, that concept of exclusivity is just not something they're familiar with. So it was a lot of really bad luck for that one agent. On the upside, I think their daughter got into the college that she wanted to, so they had that. So, yes, sir. Okay, so the question was, what would the steps be if a buyer was unhappy with me as the broker? What would they need to do? Well, it's like any other contract. They would have to express in writing that they wanted to terminate. It's designed to protect you. It would be a business model decision on how you handle that. We have brokerages who sign this document, meet with clients, and then waive all those rights and let them go on their merry way. We have brokerages who sue to enforce this on a regular basis in Clark County. So it's an individual business model. We tried to give you as much legal rights as we possibly can in the document, and then let you as brokers decide what you want to do. So if a buyer wanted to get out of this, it's a breach. They breached the contract, and then you would have to decide as a broker if you're going to let them out. You're entitled arguably to a commission, and then you would decide whether or not you wanted to enforce that or not. At the very beginning, you identify how long the listing agreement would how long it would last. You set that the first section. For the purposes of antitrust law, I can't answer that question because I can't give specific business models. There's a variation, a variety of time depending on price point, the market. All of those market factors are going to impact. Right now in Las Vegas, the $300,000 and below price point, houses sell really, really fast. But if you're looking for something at a larger number, high six, low sevens, that takes a little bit longer. So it would be a business model decision based on how long, and it would also depend on my time frame if I'm your buyer client. We have a lot of military folks coming into town, and they have to get a place relatively quickly. Or if they're moving into the area. So there's going to be a variety of factors. I don't think there's a specific number that's going to work in every scenario. But I don't sell real estate. I don't even do it on TV. So you guys would know the answer to that. Again, if you have people in your business, your office, if your broker isn't here, please, please, please share with them the idea of the damage cap. I can't tell you how much that's going to protect you down the road if if it impacts your decision to start using these, because it is a deterrent against lawsuits. And all it takes is one. I like to joke with people that you're not a successful business person in America until you've been sued. And unfortunately, it's our state law landscape. Pursuant to state law, only a broker can receive compensation for real estate services. And that's essentially what this document does. It basically says, look, regardless of whatever the listing agent's going to offer me, there's going to be some payment, and there's those kinds of things. So there's a couple ways you can do it. You can I don't know, get around's the wrong phrase. There are a couple ways that you can address this, and it's going to depend on your individual brokerage. NRS 645 does allow brokerages to identify agents who can sign on behalf of their brokerage. Whether or not they do that is a different thing. But making sure that we did not put well-intentioned agents signing this thing, which is proof that they're operating outside their scope. And I like Jan Hawley, the chief investigator of the real estate division. He's a friend. He's really good at his job. We don't need to give him any extra stuff. He can do that all on his own. So I was mindful of that when we drafted this, so that we didn't make agents believe that they can execute this on their own. So you will have to talk to your broker as to whether or not you're going to use this form and how to do that presentation. It's not a required form in any way, shape, or form. It's just a tool in the toolbox if you want to use it. Let's do the termination of the buyer brokerage agreement next. So what we did is there is going to be those situations where you have, yes sir. You could potentially address, and I have to be really careful on how I answer this question. You could arguably address anything in additional terms. You need to talk to your broker on those situations. Unfortunately, because I'm arguably a representative of the association for federal antitrust purposes, I can't tell you what is an appropriate thing to do based on commission. It's a violation of antitrust issues for me to come in and say you should do this. You can, if you have specific questions on how to do that, you need to speak to your own attorney or come up with the language on your own. So we also created a cancellation of the buyer brokerage agreement. It's an addendum that would allow you to address the situation that I'm sure would never happen to you, that someone doesn't like you and doesn't want to work with you. We all know that's never happened to anyone in this room, but hypothetically speaking, there might be a client who is difficult and his name might be Dave Sanders. This is a one-page document. Again, you're going to need to speak to your broker on if you're going to use this, what situations you'd want to use it. It's a tool, but if you have the situation where the buyer and the broker just don't get along, and you want to terminate, there are a couple options here. You'll pay me a flat fee to let you out of the agreement. You'll pay me all my expenses to date, which is number 2. Number 3 would be I'll just let you go. Best of luck, unless I can get some kind of referral agreement with your new agent. And 4 would be other. This is going to be highly fact-based if you're going to use this at all. So, and you all are brokers and agents. You understand those situations where sometimes things just don't work out. There will be times maybe that if you're maybe didn't have the best customer service that you want to just let them out. There might be scenarios where I am just a recalcitrant buyer, and you want to cover the expenses that you paid. So we gave you a document that would allow you to do that. And then if you go down a little bit, the agreement will terminate 2 days after this document's executed by both parties. Additional pages and addendums if you have them, and then places to sign. So I can't really spend a whole lot of time on this. It's a tool that you would use if you have those situations. Maybe you haven't because you're all great agents, but if you ever have the situation where you want to end that agreement with the buyer, this is a document that should be able to address most of those concerns. As a side note, if you're going to, we don't have like a settlement and release document, like if you have a client that's threatening to sue you and all those kinds of fun things. If you ever get in the situation where you decide to pay somebody to make them go away, I would recommend that you have your attorney add a little bit of language to their standard settlement documents. Most attorneys are not really familiar with the real estate division, and they're not really familiar with the code of ethics. And so we've had the situation in Las Vegas where honestly, the agent really screwed up. So broker decided to throw some money at the client to settle this potential lawsuit as a business decision. The attorney that they hired did the standard legal release of all claims that only addressed claims down at the courthouse. So after this person got their several $1,000s, they filed complaints with the real estate division and they filed complaints with the association alleging violations of the code of ethics. Now my point is, if you're gonna pay somebody to go away, you should pay for them to go all the way around. So I recommend that you add language that says including any and all administrative and trade organization claims and activities. Most attorneys are not familiar with the fact that you could probably get dinged by the division and your local real estate association. So if you ever get in that situation, and none of you ever will, but hypothetically speaking, if you ever get in that situation, make sure that your attorney adds that type of language. Unless you, I'm sorry? Sure. As long as the release of all claims, typically there's a provision in that contract where the parties agree to give up all claims, and they usually lead them to just legal claims. So you would want to include a phrase including any and all government administrative and trade organization actions as well. So that should be able to cover. Now, fortunately, fortunately for the agent who got involved with this, the professional standards panel did say, they waived the claims against them, but they had to go through the process, and there's an opportunity cost and all that kind of fun stuff. And my thought is, again, if you're going to pay somebody to go away, you want them to go away in every venue. Okay? All right. I want to take a few minutes to talk about wire fraud, then we'll take a break and we'll jump into the listing agreement. So can we go to the wire fraud form? So, as you guys know, hackers, criminals, are getting really, really good at hacking real estate related emails and then sending fake wire fraud instructions. Last year at the National Association of Realtors conference, they had 3 FBI agents come in. It's the increase of these types of cases have gone up by 100, 200%. They're looking at hundreds of millions of dollars worth of damages. In Las Vegas alone, I know of at least 4 brokerages who paid between $75,000 and $100,000 to clients to make this stuff go away. There's a growing trend on the East Coast where so what the situation is your email gets hacked and the hacker watches, and then they spoof your email and it looks exactly like yours. Phone numbers are changed so you can't even use the internal phone number on the email to call. They build a fake website, and then right before closing they send an email out saying to your buyer, wire instructions have been changed, wire to these funds. And if you don't catch those funds within the first 24 hours and they get offshore, they're gone. And you can contact the FBI. There's a local office in Las Vegas. They're pretty aggressive about helping, but if you don't know that this is happening in the first 24 hours to 48 hours, it's probably gone. So, unfortunately, what's been happening is that buyer who opened up the email that they thought was from you and sent their life savings to someone in Russia, instead of getting angry at the hacker, they're suing you. Because your email got hacked and you're a professional, and how dare you? And unfortunately in New York, they're winning. So we created this document, a wire fraud notification disclosure, to alert clients regarding potential risk related to the funding of transactions. It's designed to be used by any client, not necessarily buyers or sellers. If you do property management, this could be a potential issue. And it tells them, hey, criminals, hackers are targeting email accounts of parties involved in real estate transactions. They can come from the title companies as well. Mortgage brokers, real estate agents, and they're highly sophisticated. This is not the email that, hey, I've just won $10 million from some lottery in Swahili land. Please send me your bank account stuff. This is highly, highly sophisticated stuff, and it's only getting worse. It's not getting easier. Among other concerns, this can lead to fraudulent wire instructions being used to divert funds to the criminal's bank accounts. These emails may look like legitimate emails from the proper party. Then your brokerage name here strongly recommends that you and others working on your real estate transaction should refrain from placing any sensitive personal and financial information in an email directly or through an email attachment. When you need to share social security numbers, bank accounts, credit card numbers, wiring instructions, or similar sensitive information, Brokerage recommends using more secure needs, such as providing the information in person, over the phone, or through a secure mail or package service whenever possible. Never trust wiring instructions sent via email. Cyber criminals are hacking email accounts and sending emails with fake wiring instructions. These emails are convincing and sophisticated. Always independently confirm wiring instructions in person or via a telephone call to a trusted and verified phone number. Never wire money without double checking that the wire instructions are correct. You should call them at a number you obtain on your own, i.e. through the residential purchase agreement or their website. Never anything in the email, because it's going to be not legitimate. And not use the phone number or any content information in the email in order to be sure that you are contacting a legitimate party. Now, so there's a lot of language out there that some brokerages may have this. This is my favorite. Client shall defend, indemnify, and hold brokerage, its officers, agents, employees, and brokers harmless from any and all claims, injuries, damage, losses, or suits, including attorney's fees, arising out of or resulting from wiring instructions or similar sensitive information. So not only are you telling them this is out there, they're waiving the right to sue you if it's your email that got hacked. Okay? So it's designed that and we did it as a standalone form because we wanted it to show that how important it was, and you could pull it for any type of transaction. So if you're not using something like this, I strongly recommend that you do. Your title companies may have some language in the emails they send, never ever trust, etc., but it doesn't have the indemnification language protecting you from them suing you, unless you want to be sued, and if you do, see me afterwards, I'll give you my business card. So, any questions on the wire fraud notification? If you're not using something like this right now, please start to protect yourselves. Okay. Yeah, but if you're using one, make sure that this one has the language where they agree to not sue you. Most of them don't. It's just a general notice of, hey, wire fraud's a bad thing. This is, hey, wire fraud's a bad thing, and you're signing that we told you not to do this. Okay. But let's jump in and talk about the listing agreement. Now, there are several listing agreements. There's an ER list. Thank you. I feel like now I have to talk about the bride and how happy we are that they finally found love. I mentioned to one of my friends that I was up here today, and I sent a picture of the place, and the first thing she said was, "That's where I got married." And to which I responded, "We are having more fun because we're talking about real estate forms." So listing agreement. There are 3 different listing agreements. There's an ER, there's an EA, and there's a vacant land agreement. So that we all don't go crazy, we're going to talk just about the ER agreement because the language is about 99.9% the same. For today's purposes, we're just going to hit on the ER listing agreement. If any of you focus and do a lot of vacant land, come see me. I'll point out the 3 differences between afterwards. But the idea was to focus on the one that you're probably going to primarily use the most, which is the ER agreement. So, exclusive right to sell, seller name, company name known as brokers, commencing on date, expiring at 11:59 p.m. Pacific time on blank. However long you want to have that listing agreement, again, you're the real estate professionals. I am not. You would tell me how long that is. Identifying the property location, county, APN, all that fun stuff. Terms of sale. Listing price shall be blank. We added this recently with the suggested amount of earnest money deposit of blank. So you're having the conversation with your seller about what type of earnest money deposit should we really be looking at. So that, and again, that will depend on the price point. And again, it's suggested, it's not going to be contractual, it's going to be whatever the buyer says, but you're having that conversation with your seller client. Look, for your $85,000 condo, it's probably not wise for us to ask for an $85,000 earnest money deposit. But for your $18.5 million mansion, maybe a larger number is appropriate. Then we're going to walk through what types of financing, cash, conventional FHA, lease, VA, lease option, owner carry, other. This one, seller does or does not authorize broker to disclose the existence of multiple offers to purchase the property to potential buyers with the seller's initials. So you're having that conversation with the seller. Can we disclose multiple offers? And you've got it in writing that they said yes or no. So then if you run into the situation where I say I don't want you to disclose the existence of multiple offers, it's in writing, and when the other agents call you, you can tell them, fortunately my client has not authorized me to disclose the existence, if any, of multiple offers. Okay? Property offer for sale, list price noted above includes this plus any personal property. Now, unencumbered and escrow by a valid bill of sale. And then these items are what's going to be excluded. So the first section is, these are the kinds of personal property we want to include. This is stuff we want to exclude. This is also designed again so we don't have the scenario we talked about yesterday with the chandelier. Any type of personal property we want to have excluded will be identified here. Seller intends that the above items be excluded or included in offering the property for sale. Seller understands that the purchase agreement takes precedent over any intention identified above and will ultimately determine what items are included and excluded in the sale, and that the broker is not responsible for and does not guarantee that the above items will be in the purchase agreement. Then we talk about what are leased or liened items: solar panel, alarm systems, propane tanks, water softeners, or anything else that may impact the sale. Title insurance, seller agrees to provide buyer with an owner's policy of title insurance, the amount of the selling price. Compensation to the broker. Compensation is solely a matter of negotiation between broker and seller and is not fixed, suggested, controlled, or recommended by IVR, MLS, or any other person not a party to this agreement. Seller agrees to pay broker as compensation for services as follows: percentage point, flat fee, and then whatever they're going to offer. Since we're talking about this, have you guys heard about that case out of Texas? So there's a case out of Texas where seller's agent, specific numbers were put in here in the listing agreement as to what was going to be offered. Seller's agent then offered less on the MLS and kept more themselves. That lawsuit did not go well for him. The courts determined that it was fraud. And so I'd like to point out, not that any of you would commit fraud, but whatever is here should be whatever you list in the MLS. Again, not anticipating you don't do that, but that case is about 6 months old, so there's actual case law that that action is possibly, well, it is fraud and potentially a crime. So we also have language if you're going to lease it, if you're a property manager and you're leasing the property here, that would be language there. Compensation shall be due if the property is sold or leased by broker or through any other person, including seller, in the above terms or any other price terms acceptable to seller during the above time period or any extension of that time period. If the property is transferred, conveyed, leased, rented, or made unmarkable by a voluntary act of the seller without the consent of the broker during the time period. If within blank calendar days of the final termination, including extensions of this agreement, the property is sold, conveyed, or otherwise transferred to anyone with whom the broker has had negotiations or to whom the property was shown prior to the final termination. This section C shall not apply if seller enters into a valid brokerage listing agreement with another licensed real estate broker after the final termination of this exclusive listing agreement. In the event of an exchange, permission is hereby given to broker to represent such parties as broker may be deemed appropriate and collect compensation from them, provided that there is full disclosure to all parties. If completion of the sale is prevented by default of the seller or refusal of the seller to accept an offer in accordance with the price and terms of this agreement, then upon event, broker is authorized to take any action reasonably necessary to collect said commission. If completion of sale is prevented by a party to the transaction other than the seller, broker may collect its commissions only if and when seller collects damages by suit or otherwise, and then an amount not less than 1/2 of the damages recovered, but not to exceed the above compensation after first deducting title expenses, escrow expenses, and expenses of collections, if any. Now, I hope you never have to use D, but we put the language in there just in case you have a scenario where your client, the seller, intentionally sabotages the deal, or the buyer intentionally sabotages the deal, and everybody sues. But it's there just in case you actually have that scenario, because we've unfortunately had that in Southern Nevada. Broker is authorized to cooperate and divide with other brokers the above compensation in any manner acceptable to broker. Seller hereby irrevocably assigns to broker the funds and proceeds of seller in escrow equal to the above compensation. In the event any sum money due under this agreement remains unpaid for a period of 30 days, such sum shall bear an interest rate at blank% per annum from the due date until paid. Now you could put a number in there if you really want to. I will also tell you that Nevada does not have what they call usury laws, meaning that we don't have a cap on interest rates. The highest I've ever seen a judge hold up in a courtroom was 47%. I'm not recommending that you do that, but what I'm saying is you have some leeway there. And again, and this is an individual business practice. If you want to do this, you could always just put 0 right there. Number 6, broker is authorized to accept on seller's behalf a deposit to be applied toward purchase price or lease. Said deposit shall be held by. So why you would want to accept an earnest money deposit, I have no idea, but if you really want to, we'll give you the ability to do that. All right, let's jump into agency relationship. Broker warrants that he or she holds a current valid Nevada real estate license. Broker shall act as the agent of the seller and may also assign or designate a licensee of the broker who shall act as the representative of the seller in any resulting transaction. Depending on the circumstances, it may be necessary or appropriate for the designated licensee to act as agent for both seller and buyer, exchange parties, or one or more additional parties, if applicable. Broker and the designated licensee shall disclose to the seller any election to act as an agent representing more than one party and obtain the written consent to act form signed by all parties to the transaction. C, broker may also have licensees in its company who are agents of the buyer who may show and negotiate an offer to purchase seller's property. In this event, the licensees who represent the buyer will only represent the buyer in the transaction, with all duties owed to the buyer and not the seller. This, therefore, does not require a consent to act form. Any questions on that? Huh? Required disclosures, unless exempt under NRS Chapter 113, seller shall truthfully complete and sign a seller's real property disclosure statement concerning the condition of the property. Seller shall update the seller's real property disclosure as necessary. If the property is or has been subject of a construction defect claim, whether litigated or not, seller shall provide the disclosure as required by NRS 40-688. If the property was built prior to 1978, seller shall complete the disclosure of information on lead-based paint hazards in accordance with federal regulations, and seller acknowledges receipt of the residential disclosure guide. Pursuant to federal regulation, you do not have to include the lead paint stuff if the property is built after 1978. My favorite section, the indemnification section. Seller agrees to save, defend, and hold broker, Incline Village Realtors, and the MLS harmless from all claims, dispute, litigation, and or judgments arising from any misrepresentation, breach of warranty, or breach of a promise by seller in this listing agreement, any incorrect information supplied by the seller, any facts concerning the property not disclosed by seller, including any facts known to seller related to adverse conditions or latent defects, the use of a key box, or any injury or damage to persons or property in connection with the marketing or showing of the property. This indemnification shall survive broker's performance in any transfer of title. Again, designed to protect you from just about any possibility we could think of where a seller would try to sue you or your association. Just because the language is there because it's the Incline Village that's providing the forms, and so it's designed to protect that association. It's not designed to protect every association out there. I can't really see a scenario where you would have the ability, for example, to sue the Carson City Association and not, I don't really see that as a potential issue. We just wanted to disclose and waive liability related to any seller. So the idea was, is hypothetically a seller makes up all kinds of stuff about the property. You put that in the MLS. Buyer finds out that, wait a minute, this place is made of lead paint and there's uranium in the backyard, and we rather than filling the pool in, I just got a dump truck and dump some dirt and debris in the back, which has actually happened in Las Vegas. And it's not 7 bedrooms, it's really 1.5 made of like plywood. But here's all the fake pictures I found on the internet, so you go ahead and use that. So the idea is that if the buyer turns around and sues the seller for misrepresentations about the property that they knew or should have known, the seller's going to indemnify you, going to indemnify the MLS if the MLS gets sued, and the Realtor Association. Again, this hasn't happened. I'm just being overly protective. The question was, it just says MLS. Yep, we went with the generic MLS just because there's a possibility, depending on where you send the feed, I didn't want to have to identify every specific MLS that could potentially have the feed, so we went with generic with the MLS. All right, 10, fair housing. Broker shall offer the property for sale or lease without regard to race, color, religion, sex, national origin, age, gender identification or expression, familial status, sexual orientation, ancestry, or handicap, and any other current requirements of federal or state fair housing laws. Just to remind you, I'm sure you all know this, but Nevada's fair housing laws are a little more expansive than the federal one. So if you are complying with Nevada, you will comply with the federal regulations. All right, CICs. So this language here is just to identify if the property is located inside a HOA. We went with 3 because that's the max of HOAs that I am aware of one property having in Southern Nevada. Those poor homeowners who have to deal with 3 HOAs. Makes me wonder what they did in life to make karma so mad at them. So that's the information there. And then they have to verify if they're current on their dues and assessments. Okay. If the property is located within a CIC, seller acknowledges and agrees to obtain at seller's own expense as required by NRS 116.4109 and or provide the information required by NRS 116.4109 and NRS 116.41095 to broker for delivery to buyer. That's the resale package, okay? Special assessments, the property is or is not subject to special government assessments such as SIDS and LIDs. For more information, go to that website. If yes, please complete the following, where you identify what the SIDS and LIDs are, and how much is left and whether the payment's due monthly, quarterly, semi-annually, or annually. 13, sign. Seller does or does not authorize a broker to install a sign. 14, key box. Seller does or does not authorize broker to install a key box, and we let you identify whether it's electronic or mechanical. In connection with the showing of the property, a mechanical key box is a combination type box. It can be opened by anyone who has access to the combination/code. The MLS requires that a valid working code for a mechanical key box be included in the listing for ease of showing. The code is a confidential field that is not intended to be available to the public. Seller acknowledges they've been advised that the purpose and function of the key box is to permit access to the interior of the property by all members of IBR's MLS, as well as any licensed professionals necessary to facilitate the sale of the property. Sellers should safeguard personal property and valuables located within the property. It is not a requirement of the MLS for a seller to allow the use of a key box. Where a tenant occupies the property, the tenant's consent is also required, which shall be obtained by the seller or his or her property manager. Do you guys offer one-day codes up here? What's your, and I don't know, I'm sorry, what lockbox company do you guys use? Supra. Okay, does Supra allow one-day codes? We use SentryLock, that's why I wanted to make sure. So one-day codes access installed on the property. A one-day code is an electronic means to allow access to the key box key compartment. Broker shall only issue such codes to licensed professionals. Broker further agrees to use all reasonable means to verify the identity of said licensed professionals. And then the last one, owner acknowledges that IVR, the MLS broker or its listing agent, is not insuring the owner or occupant against theft, loss, or vandalism resulting from such access. Owner is responsible for taking such steps as may be necessary to secure and protect the property during any time that a key box is being used and obtain appropriate insurance. So the next sentence is the key. The code is a confidential field that is not intended to be available to the public. So it's in the agent-to-agent remarks, typically is where we put it. In GLVR's MLS, if you're printing out the agent-to-agent and confidential and hand it to your client, that's a no-no. I don't know what your MLS rules and regs are here, but I wouldn't do that. If I, anything that's confidential, we wouldn't give out to the public. But you guys may have different rules than we do. I don't know what your Northern MLS rules are. A couple things about this section that's kind of interesting. We talk about how that the owner needs to be aware of their valuables. In God Love Nevada, the first question I got on this was, so now that marijuana is legal, I would consider your recreational or medicinal marijuana to be something that you should safeguard. I had the question of, well, what happens when they converted one of the bedrooms into a grow room where they had all kinds of marijuana? I was like, I don't know if you, and then the problem became, the amount in question, they couldn't necessarily transport it because of the regulations on that. So if you run into the situation where you have clients who have recreational or medical marijuana, I would advise that they lock that stuff up so that, when random people are walking through the house, don't decide to come back later and get your stash. Yeah, what that agent ended up doing was on that second bedroom, they took pictures, and then they locked the door and they put a sign out in the front and said, "Caution, sensitive medical equipment herein, do not access." I don't know if that worked or not, but that's what they ended up doing. It was a lot more difficult before recreational became legal, but again, be mindful of fun stuff like that. Let's move on to the rent or lease section, where the owner is going to identify whether the property is or is not occupied by a tenant. The property is subject to a management agreement, such as the name of property manager. Seller agrees not to rent or lease the property during the term of this agreement without 14 days prior written notice to the broker. Tax withholdings. Let's talk about FIRPTA, my favorite 6 letters in the English language, FIRPTA. All right, seller agrees to perform any act reasonably necessary to carry out the provisions of the Foreign Investment in Real Property Tax Act, or FIRPTA. As applicable, as designated in the seller's response herein, seller agrees to complete, sign, and deliver to escrow holder a certificate indicating whether seller is a foreign person or non-resident alien pursuant to the Foreign Investment in Real Property Tax Act. A foreign person is a non-resident alien individual, a foreign corporation not treated as a domestic corporation, or a foreign partnership, trust, or estate. A resident alien is not considered a foreign person under FIRPTA. Additional information for determining status may be found at the IRS's website. Seller understands that if seller is a foreign person, then buyer must withhold the tax in an amount to be determined by the escrow holder in accordance with FIRPTA unless an exception applies. Seller agrees to sign and deliver to the escrow holder the necessary documents to be provided by the escrow holder to determine if withholding is required pursuant to 26 U.S.C. section 1445. And then we have the section where they tell you whether or not they're declaring for FIRPTA, because the way FIRPTA is written, if you know as the seller's agent that they are applicable to FIRPTA and you don't take the necessary steps, the Internal Revenue Service can come after your commission and you, which is why I put this in here so that you can tell the Internal Revenue Service, we asked them, they declared they were not or they were, and I reasonably relied upon the representations of my client. Now, I'll be honest with you, I haven't heard of anybody who we've had to have go up against the Internal Revenue Service on this. I hope this language is sufficient, but it is the Internal Revenue Service, and they're inherently grumpy. So, okay. Any questions on FIRPTA? The key with FIRPTA, if your client marks that section, you need to find an escrow holder that actually does FIRPTA. There are some exceptions. We could spend the entire day talking about FIRPTA. And if you're a property manager that deals with foreign owners, that's a real nightmare to comply with FIRPTA, because you're supposed to be withholding a certain amount of the rent every month. So if you have FIRPTA questions, I am not an expert on FIRPTA. Yes, ma'am. So the question was, does this apply to people who have dual citizenship? If they are a citizen of the United States, probably not. FIRPTA typically doesn't apply to someone who is in the country legally. So if you are if you've got a green card, if you've got dual citizenship, it probably does not apply. With the caveat that you will need to verify that with the escrow holder. I'm not an expert on FIRPTA. It's an extremely complex part of the law. You would need to verify. I don't think they are, but verify on your own. Did all of you get through the night? You were so excited to come in here and talk about FIRPTA today? I couldn't sleep. I was so excited. It's like the highlight of my day to talk about FIRPTA. Okay, mediation provision. Again, broker and seller agree to mediate their disputes, resolve any dispute related to this listing agreement which remain between the parties. If the dispute cannot be resolved by negotiation, the dispute shall be submitted to mediation. Mediation fees, if any, shall be divided equally among the parties involved. Each party is encouraged to have an independent lawyer of their choice review this mediation provision before agreeing hereto. By initialing below, the parties confirm they have read and understand this section and voluntarily agree to the provisions thereof. Multiple listing service language tells them that unless the seller tells us not to send it to the multiple listing service, we're going to send selling information to the MLS, and that you're authorized to cooperate, report price, terms, financing, publication as required by the MLS. Okay? Advertising. This is an interesting section that we recently added because of lots and lots of lawsuits by photographers. And I'm sure you guys follow those things like I do, right? Lawsuits with photographers. So there's been a series of lawsuits with photographers suing real estate agents and then third-party portals over MLS photos. Okay? One thing and why we included this language is that you need to make sure that the ownership rights to the photographs are transferred so that your multiple listing service can file. In Southern Nevada, we do it quarterly with the trademark office to protect the data. We've had scenarios where groups like Neighborhood City came in, scraped the data, and tried to use it on other websites. Because we trademarked it, I was able to send a series of cease and desist letters, and they backed down. So one of the ways we protect your data from folks who scrape it, steal it, want to use it for all kinds of other things is to file with the trademark office. The problem with that is we have to guarantee or swear out to the trademark office that we have the ownership rights to the photos, to the compilation, etc. So this language was added. The seller acknowledges that unless the seller signs a photo exclusion, photographs of the property may be taken for publication in the MLS computer system. Subject to Section 20, which is the opt-out section. Seller agrees that the property may be advertised in any and all formats of media, including but not limited to electronic and print advertising. Should seller provide photographs of the property, seller warrants and represents that seller has the ownership rights to said photographs, and by providing said photographs, irrevocably assigns any and all ownership rights to the broker. Seller further acknowledges that once images are placed on the internet, neither the broker nor the seller have control over who can view such images and what use viewers may make of the images or how long such images may remain on the internet. Seller acknowledges that prospective buyers and other persons coming on to the property may take photographs, videos, or other images of the property. Seller understands that broker does not have the ability to control or block the taking of or use of images by such persons. Once the images are taken and or put into electronic display on the internet or otherwise published, neither the broker nor the seller have control over how such images are used. So if you have the scenario, we have the client gives you photographs. We need the language there to protect you. Now, if you're using professional photographers, make sure that you're getting necessary rights. We have 3 agreements that NAR drafted that I updated for Nevada law that allow you different use for professional photographers, including limited licenses, ownership rights, etc. Why that's important is there's a group of photographers that are suing a little group called Zillow. I don't know if you've heard of them or not. And what they did is they claimed that they had a limited license so that the realtor, you hired this photographer to take photographs. And the photographer's limited license was just for the advertising of real estate. What Zillow was doing, pursuant to whatever agreement language they had in their agreement from the agents, they were taking those photos and using them for their apartment website, right? And so these photographers sued Zillow, and they've actually been successful so far, for misuse of the right. The scary thing for you guys is what Zillow did. Zillow made a motion to the court up in Washington that there were indispensable parties not subject to litigation. So basically, it's a motion where you say, Judge, these people are absolutely necessary for us to resolve these disputes, and you need to order them to come and be part of the lawsuit. Any idea who they claimed the indispensable parties were?
Every person.
All of you. So not only did they potentially slide push you under the bus, they picked you up like WWE style and slammed you under the bus. Now, fortunately that motion was denied, but that's why these rights are so important to have, so that we can avoid those types of lawsuits, okay? The next paragraph talks about, and then we talk about, hey, once the photos are out on the internet, we have no ability to stop those. We had a scenario where former Senator Harry Reid listed his property for sale in Southern Nevada. And a realtor took those photos and leaked those photos to a website who then used the photos to allege that, if you remember, Harry Reid, Senator Reid, had a significant eye injury. He claimed that he was exercising with resistance bands and caused some permanent eye damage. So this realtor leaked the photos to this website, who then took the photos with the watermark across it that said MLS, and came up with a conspiracy theory that due to the dimensions of the home, Senator Reid's injuries could not have been caused by a resistant band, but it really was a drunken brawl with his brother. My 5 minutes of fame on that website was when I wrote them a cease and desist letter and they posted it up on the front. Because we had the ownership rights, we were able to tell them we were not a fan of you using our photos this way, you need our permission. So that's an example of what happens, how people can just take those photos and use them for any purpose. We really don't have much ability to stop them. Okay? The next paragraph talks about, hey, people are going to be walking through your house and taking pictures. As a side note, if you're a buyer's agent, buyers technically do need seller's permission to live stream the interior of my home. Now, I'm not going to make you, I don't recommend that you have to be a policeman and verify that, but we put this language here so you could tell the seller, hey, there is a possibility when a buyer is walking through, they're taking pictures, they may post that up on YouTube. We don't have any ability to stop them, and we're not going to police that. There are forms that the National Association recommends. There's 3 of them, and it depends on your price point of how much you want to charge the photographer. We updated them. They're part of the forms that we sent to you guys. I have no idea whether your Northern MLS uses them or not, but NAR drafted them about 2 years ago. I just made sure that they complied with Nevada law and updated some jurisdictional stuff so that we wouldn't have to sue in another state. And they're available for your use. You're right. So the question was, is the situation with the agent and the photographer? You're right. This document does not. But we have 3 model photography agreements that does address that issue. That's in your library, and so. And it's going to depend on how much you want to spend. Some photographers do not want to give up ownership, and you can have a limited license for real estate related and advertising purposes. That's sufficient for the MLS and for your business. Those forms are out there that you can use. And again, NAR wrote them about 2 years ago. So they're available for you to walk in with the photographer. You don't necessarily have to rely on the photographer's professional agreement. You can have your own that's a little more fair and balanced, and that's available as part of the form bank. Number 20, seller opt-outs. So those of you who remember about a decade ago when the Department of Justice came in and tried to make the argument that the multiple listing service violated federal antitrust laws, and NAR entered into a consent decree with the Department of Justice on VAL roles and advertising on the internet. So Section 20 is the opt-out provision that is required by that consent decree. Now that consent decree expires this year. NAR about a month ago indicated that they don't anticipate changing that language, but that section is required. And so this language is required for all NAR-owned MLSs. So it shouldn't be anything unusual for you. But I would prefer it not to be in Spanish because I don't speak Spanish. Most people who are looking to buy a home, they start on the internet. They look and see. Now, why you would want to take photos with your iPhone when you could hire a professional and have really good photos for that first impression? I'm not a real estate agent. I don't know why you would want to do that, but you certainly could. Or you could hire, a family member with a good camera. You could do that. You have those ownership rights. But when you hire a professional, you need to be mindful of what they're actually giving you. You want to make sure that you have the ability to use the photographs for real estate related advertisement, not just when the property is for sale. That's one thing that they have a tendency to kind of restrict. So that, for example, once the property is sold, you may want to be able to use that photo on your website of proof of how awesome you are and the other sales you've done in the past. Depending on how that agreement says, you may not have the rights to do that.
All right, let's start back up with the opt-out language. So again, this is the stuff that NAR requires us to have in the listing agreement pursuant to that consent decree. So Seller further acknowledges and understands that the MLS will disseminate the property's listing information to those MLS brokers and agents and their web vendors who operate internet sites as well as other online providers, and that such sites are generally available to the public. Some but not all of these websites may include a commentary section where consumers may include reviews and comments about the property in immediate conjunction with the listing, such as blogging, or provide a link to the comments. In addition, some but not all of these websites may display an automated estimate of market value of the property in immediate conjunction with the listing, or provide a link to the estimate. Seller can instruct the broker to have the MLS not display the property on the internet. Seller can also instruct the MLS to not display the property address on the internet. Seller understands these opt-outs would mean consumers searching for listings on the internet may not see the property or property's address in response to their search. Seller may opt out of any of the following features by initiating the spaces below. These are ones that are required at least till the end of the year. So, don't want to have a commentary section. And the next one is don't want an automated estimate of value. Now, if your client doesn't want it listed on the internet at all or their address, address that in the additional terms. But A and B are the two required opt-outs that NAR requires until the end of the year. Now, I can't tell you what our good friends in the Department of Justice are going to do. NAR's attorneys are very confident that they're not going to have to continue with the consent decree, but they're going to require this language to be in the listing agreements no matter what. This has been required language for over a decade. So there's our MLS, they have the ability to mark that within the MLS listing to say, don't do these two things. I'm absolutely certain that your MLS up here has that. But in reality, I can't imagine anybody, when they created these requirements, 10 years ago, the internet was a very different place. I can't imagine any seller today in 2018 saying, don't display my house on Zillow, don't display my house on the internet. Can we put it in the Thrifty Nickel instead? I don't see that really happening anymore. These rules only apply to NAR-owned MLSs, so it only applies to the MLS. So if I have Sanders Real Estate and I have a direct feed to Zillow, which I can totally do with my own listings, these restrictions don't apply. All right, let's go with use of listing content. 21. Seller acknowledges and agrees that all photographs, images, graphics, video recordings, virtual tours, drawings, written descriptions, remarks, narratives, pricing information, and other copyrightable elements relating to the property provided by a seller to broker or broker's agent, known as the broker's listing content, and any changes thereto may be filed with the MLS, including in compilations of listings and otherwise distributed, publicly displayed, and reproduced in any medium. Seller hereby grants to broker a non-exclusive, irrevocable, worldwide, royalty-free license to use, sub-license through multiple tiers, publish, display, and reproduce the broker listing content, to prepare derivative works of the broker listing content, and to distribute the broker listing content or any derivative works thereof in any medium. This non-exclusive license shall survive the termination of this agreement for any reason whatsoever. Seller represents and warrants to broker that the broker listing content and the license granted to broker for the broker listing content do not violate or infringe upon the rights, including any copyright rights of any person or entity. Seller acknowledges and agrees that as between the seller and broker, all broker listing content is owned exclusively by broker, and seller has no right, title, or interest in or to any broker listing content. All right, so that's a lot of legalese about broker content. That listing content they give you is yours. You can transfer it to the MLS. You can use it for your own businesses, and they don't have any ownership rights. Nevada law. We're going to agree that Nevada law is going to govern this contract, and that we're going to agree that the county where the property is located is the appropriate place to sue if we decide to get that. 23 is an entire contract section. All prior negotiation agreements between the parties are incorporated into this agreement. And then 24, again, partial invalidity, standard lawyer boilerplate stuff here. 25, attorney's fees. Again, 26 is our awesome damage cap provision. It talks about that if they decide to sue you, all they're ever going to get is your commission. 27, warranty of ownership. Seller warrants that they're the owner or they have the authority to execute this agreement, again for corporations, trusts, etc., and that they understand and agree to the terms. Foreclosure. Seller understands that the failure to make loan payments may result in foreclosure of a property by a mortgage holder. Information concerning the foreclosure or litigation status of a property is available from the county recorder where the property is located. Seller represents the time of the listing, and then they identify whether or not there's going to be a notice of default, so if there is a notice of default, and then determine whether there's a summons and complaint. It's just so they're giving you the status, if the property is in foreclosure, what the status of the foreclosure process is. Ideally, we never will have to go back to 2007 where this is really, really important information, but it's there anyway. And then C tells them if we don't sell it before the foreclosure, you lose the right to all interest in the property, and that the broker can't stop the foreclosure. Okay. All right. Any questions on that? All right. 29. Signatures. Basically, you can sign the agreement in more than one copy. Number 30 is a personal favorite of mine, the recommendations provision. This is designed to stop you from getting in trouble with my other favorite acronym, RESPA. We know that your clients are going to ask you, hey, do you have a good handyman, do you have a good contractor, do you have all those kinds of things? And to avoid them saying you gave me a terrible, horrible person, I'm going to sue you, or make RESPA violations, we included this provision. If broker recommends a builder, contractor, escrow company, title company, pest control service, appraiser, lender, home inspection company, or home warranty company, or any other person or entity to seller for any purpose, said recommendation shall be independently investigated and evaluated by the seller, who hereby acknowledges that any decision to enter into any contractual arrangement with any such person or entity recommended by the broker will be based solely upon such independent investigation. Meaning, I'll give you a list of people that I think are good, but you agree you're going to go look at them and you're going to make that decision on your own, and I'm not responsible for their actions or the referral. I will tell you that I was really worried about RESPA under the previous iteration of the Consumer Finance Protection Bureau. When it was originally created and with Director Codroy, they were extremely aggressive, and they really were true believers that you were evil people destroying consumer rights. And they were extremely aggressive with RESPA enforcing, and they were really, really looking at coming down on realtors. And then we had a change in the current administration, and the CFPB is no longer the big bad wolf that it once was. So I do think it's important to make sure that we don't be mindful of, tromping all over RESPA, but it's not the major threat it was 2 years ago or 3 years ago. The question was, why isn't this in the purchase agreement? It's because the purchase agreement is a contract between the buyer and the seller. And when if a buyer and a seller want to make recommendations by pursuant to RESPA, the buyer gets to pick all of those people. What we wanted to make sure is in an agreement there, the broker and the client are contractual parties, that we have contractual language that would protect them. So the short answer is, it's not in the residential purchase agreement because the purchase agreement is a contract between the buyer and the seller, and the brokers are not third-party beneficiaries or contractors. To have any real enforcement power, it needs to be in this document. Okay, 31. If seller materially breaches this listing, seller is in default, will be liable for broker for the amount of the broker's fees specified in Section 5 and any other fees broker is entitled to receive under this agreement. If a sales price is not determinable in the event of an exchange or breach of this listing, the listing price shall be the sales price for the purposes of computing broker's fee. If broker breaches this agreement, broker is in default and seller may exercise any remedy at law. Okay? So if you have the situation where the seller breaches and the sales price isn't determining, the listing price will be what your commission is based on. So they have a breach and you don't have a sales price, you default to the listing price. Okay? Ideally, hopefully you never have to deal with that, but that's what it's for. Binding effect, seller's obligation to pay broker on an earned fee is binding upon seller and seller's heirs, administrators, executors, successors, and permitted assigns. 33, joint and several liability. All sellers are joint and severally liable. That's a legal phrase. Does everybody understand what that is? Okay.
That to do with marijuana?
No. No. So joint and several liability is a legal concept. Say you have 3 sellers. Joint and several liability says, I don't have to sue all 3 of you. I can sue just one and make you responsible for the entire amount, and then you have to sue your other 2 sellers who breached the contract. So you don't have the argument where they bring in and say, you need to sue all 3 of us. You can pick and choose. So it's designed that if you have multiple sellers and then they breach, you don't have to sue all 3 of them. You can sue one for the total amount. Okay, it's a pretty standard language in non-real estate contracts. Yes, sir. So the question is what if the seller is an LLC? All you would need is, the reason we have the
can we go back to, hold on, go back to section 29, signatures. So here, actually it's not that one. We have language in here and I can't, I'm drawing a blank.
You have to have the right.
Yeah, that they identify their rights. So an LLC is going to be the managing member, that kind of thing. You know, unless you think they're you know, piercing the corporate veil and that kind of thing, which is really beyond the scope of what we're talking about today. No, as long as they're making the representation, we have language in there that whoever's signing this has the authority on behalf of the LLC, the corporation, the trust. They have the ability to execute and sign. The contract, the language in the contract is sufficient. The person that's going to ask for a possible corporate resolution is going to be your title company or the mortgage company. They may ask for that. So I'm more of a fan of deferring to them on that. You mean, if you think that they're not acting, I mean, the language of the contract's enough to sue over, but title or escrow may require a corporate resolution. So you can go onto the Nevada Secretary of State's website or Silver Flume and pull corporate officers that way as well. There's language in here that whoever's executing this authorizes, hold on. There should be. It's number 27, warranty of ownership. Seller warrants that seller is the sole owner of their property or has the authority to execute this agreement by signing below. Seller acknowledges the seller has read and understands this agreement, agrees to the terms thereof. 34 is time of the essence. 35 is additional terms. And then there's language or signature blocks, etc. And then we also have this here, that they consent to agree to receive transmission sent from the broker to email addresses, and they advise you that if they're going to change their email address, they'll let you know within 24 hours. Yes, sir. So the question was, can we add another line for email? I'll certainly take that back and see if we can do something like that. This is all we have today. If you want to stick around and do the RPA afterwards, I'll be more than happy to do that.